If you're a parent or grandparent looking to save and invest for your child or grandchild's future, you may be considering what's called an in-trust account. While there may be some benefits to this kind of arrangement, there are some complications that could arise as well. Nicole Ewing, Director of Tax and Estate Planning at TD Wealth, joins me now with some of the pros and cons to consider. Hello there, Nicole.
Hello, Kim.
So what the heck is an in-trust account?
So an in-trust account or an in-trust for account, it's essentially a non-registered investment account or a checking or savings account that a parent or guardian typically would be setting up for the benefit of a beneficiary, of a minor child, more often than not. And they would be acting as they would name a trustee, they would name a beneficiary, and that trustee would be responsible for managing the funds, potentially making any withdrawals from that for the benefit of the beneficiary. And the beneficiary is the person for whom the funds are ultimately intended to benefit. Now, this would generally be established if the minor beneficiary had inherited funds, for example, from an estate, or if another family member wanted to gift them money, and the parent might be concerned about whether or not that minor child has the maturity in order to deal with that account. But also there's some restrictions on minors entering into contracts. And so if there's large sums of money, we're talking about large investment accounts, we might want to have a parent or a grandparent even stepping in to manage those funds. So these accounts are opened using an account opening form at a financial institution, and it would use the formal name of the trust. So trustee in trust for beneficiary. So Nicole Ewing in trust for Nicole Ewing Jr. And that would be the name of the trust. And then once that individual beneficiary reaches the age of majority in their province, they would typically then become able to use those funds and access them in the same way that they would if it was their sole name on that account.
So I guess I'm curious, this is something that somebody would set up to help, protect and manage funds for somebody who's not quite ready to do it yet. But the way which you set it up is probably less complicated than, I understand, a formal trust, but I'm sure there's some, and you're going to tell us, some cost benefit to those two, right?
Well, that's very often, they're referred to, in trust for accounts are referred to as an informal trust. And it frankly makes my skin crawl because what informal means is that there's no appropriate documentation to clarify what the rights and the obligations of the parties are. So a legal trust that's established with a deed of trust lays out what the three certainties, that the intention to create a trust, the intention about what the property will be in the trust and who's to benefit from it. And our account opening forms typically don't have that sort of information, and there's no understanding amongst the parties about what the default laws will be. And there are laws that apply to this, both trust law and tax law, that could be impacting the parties. They don't know what their rights and responsibilities are, but there might not be a clear idea of where the funds came from, what that source or who contributed those funds. There's major issues about that from a tax perspective, about who actually owes the tax on that money. Might not lay out who is to manage the money, how it's to be managed, whether it can be accessed before 18, when it's to be paid out. And the CRA might not share your view about what this account is, and they might have a different tax treatment. And then we're into the world of penalties and interest, and can be very complex when we only have this simple form to deal with an otherwise complex scenario.
I think that's a pretty good tick in the con category versus pros and cons. And I know we're going to talk more about the cons. What would then be the pros? Why would somebody want to do this?
Well, as you mentioned, these are fairly easy to open. So it's an account opening form that you would simply go to the bank and put the necessary information on. And if you're using the minor's social insurance number, it can make accounting a little bit easier. The tax forms would come in their name. But apart from that, I'm reluctant to say that there's too many pros to this strategy.
And I guess the cons, you named quite a few. Are there any that you did not tell us about?
Well, there are the situations where people just don't understand what these accounts actually mean. And so we have individuals who have transferred money into these accounts in trust for their children, perhaps doing that from a tax perspective, thinking that they'll access their child's lower marginal rate, and then are shocked to learn at age 18 that the children actually can simply demand that that money be paid out to them, and major regret on that front. There's others who simply think that they can take that money back, that they didn't really gift it yet because it's not in the child's hands yet. And so they may need that money later on and want to access it themselves from the account. That's a no-go. And then the tax really is important here, because depending on the source of the funds, where it came from, and the types of investments you're dealing with, you may have income attributed to the parent or grandparent. You may have income in the hands of the beneficiary. You may have a trust reporting obligation, a trust form to file for tax purposes. These may be bare trusts. They may be agency relationships. So a lot of unanswered questions that these sorts of trusts create.
It sounds like a lot of unexpected surprises that maybe perhaps you've dealt with when dealing with clients when putting these together.
Oh, absolutely. And I've seen it. I've been in the room and having those conversations with parents who are deeply regretful about having transferred that money into their hands. They may have actually needed it for their own retirement, not really appreciating that it's no longer their money. So we've seen those situations over and over again. And once at age 18, that can cause a real rift in the family as well, where if that 18-year-old or 19-year-old, depending on your province, what age of majority is, they want that money and sometimes make heartbreaking decisions when they have access to that money. It can cause a rift in the family, and this otherwise wonderful gift, either through an inheritance or a family member really wanting to benefit that child, could actually be creating a really unfortunate situation, when this is what trusts are designed to deal with. Go work with a professional, work with a lawyer, your investment advisors, your accountants, to create a structure that actually achieves what it is what you want to do for the child. We might need a little bit more formal documentation in place to be able to do that, but well worth the spend up front in order to avoid all of these potential challenges.
Well, it's a great insight and a bit of caveat emptor, I think, for people to understand what they need to do and who to talk to before they do it. Nicole, it is always a pleasure. Thanks so much.
Oh, thanks, Kim.